Camera trees. Background. Greetings of the day. Welcome to the final rounds of the 34th Kerala Law Academy Moot Court Competition 2025 conducted by the Kerala Law Academy Law College in association with the Kerala Law Academy Moot Court Society and IQACKLA. I am Rose Reba Prakash and I have with me Gauri Jyotish and Hari Narayan and we'll be your court officers for this final session.
Kerala Law Academy Law College, established in 1966 by the esteemed late Dr. N. Narayan Nair sir, is a seat of excellence in legal education, consultancy, research, and in pioneering law reforms. As one of the oldest institutions dedicated to legal education, Kerala Law Academy Law College goes beyond traditional classroom fort. It prepares students for lifelong legal practice by providing opportunities to showcase their skills on national and international arenas. 34th Kerala Law Academy Moot Court Competition 2025 is one such event.
Today, we are most delighted to welcome our esteemed panel of judges possessing an extensive array of knowledge and expertise to judge the final rounds of the 34th Kerala Law Academy Moot Court Competition 2025. Firstly, we welcome Honorable Mr. Justice K. Babu Sir, Judge, High Court of Kerala, as part of our esteemed panel of judges. A distinguished legal luminary, Sir, has had an illustrious career beginning with his practice in civil law and later serving in key judicial roles, including district and sessions judge and registrar at the Supreme Court of India. Sir's tenure as chairman of the Supreme Court appointed committee for the Sri Padmanabha Swami Temple further highlights his profound contributions to the judiciary. Sworn in as judge of the High Court of Kerala in 2021, Sir continues to uphold justice with excellence. It is with deep respect and admiration we extend our warm-hearted welcome to you, sir.
Next on panel, we have Honorable Mr. Justice Shyam Kumar VM Sir, Judge, High Court of Kerala. A specialist in maritime law, Sir earned his LLM from Cochin University of Science and Technology and built a distinguished career in admiralty, commercial and constitutional law. Sir has also contributed to legal education as an adjunct associate professor at NUALS and a guest faculty at leading institutions. Sworn in as a judge on 22nd March 2024, he continues to be a pillar to the legal community. With immeasurable powers and mastery, we're immensely honored to be in your presence today, sir. We extend our heartfelt greetings to you into this finale.
Next, in our reward session, we have with us Honorable Mr. Justice K.V. Jayakumar sir. Sir currently serves as a judge of the High Court of Kerala, bringing with him years of judicial experience and commitment to justice. Appointed as a district judge in 2012, he has held key positions including principal district judge in Talasheri and Kollam. Presently serving as the vigilance registrar at the High Court, he continues to play a crucial role in maintaining judiciary integrity and efficiency. His vast expertise and dedication to the legal system makes his contribution invaluable. With a wealth of experience and commitment to justice, we extend a warm and sincere welcome to you into this session, sir. We are honored and grateful to have all the three judges present here for willing to take their time out of their hectic schedule and joining us in this final session of the 34th Kerala Law Academy Moot Court Competition 2025. We humbly welcome you all to this session.
Judges, with your kind permission, shall we start the briefing session? Petitioners, please state your team code.
TCAG.
Respondent side, please state your team code.
Team code U.
So, petitioner side, how would you like to divide your allotted 45 minutes?
$20 for each speaker and 5 minutes for rebuttals.
So, respondent side, how would you like to divide your allotted 45 minutes?
15 minutes speaker 1, 20 minutes speaker 2, and reserving rest for the rebuttals.
From the petitioner side, speaker 1 will be speaking for 20 minutes, speaker 2 will be speaking for 20 minutes, and for rebuttals, you have 5 minutes. From the respondent side, speaker 1 will be speaking for 15 minutes, speaker 2 will be speaking for 20 minutes, and for rebuttals, you have 10 minutes.
Speaker 2 would be speaking for 25 minutes.
Team AG, would you like to inform you like verbally or in the chat box?
Verbally.
Team U, would you like your intimations to be done verbally or through the chat box?
Verbally.
Candidates may please note, I am going to read the rules. The total allotted time for each team is 45 minutes. The court officer will be intimating the remaining time for each speaker at regular intervals. Any additional time taken by the first speaker will be reduced from the second speaker's time. The participants are to keep the video on at all times throughout the meeting. And judges are kindly requested to note total allotted time for each team is 45 minutes. The court officer will be intimating the remaining time for each speaker at regular intervals. And with your permission, shall we start the session? Judges, with your permission, shall we start the session? This is the final session of the 34th Kerala Law Academy Moot Court Competition 2025 with Team AG and Team U. The participants may please note the session starts. The first speaker of the petitioner may begin.
Very good afternoon to the Honorable Bench. The Council would seek permission to collectively address the bench as your lordships. Much obliged, your lordships. The Council is before the Honorable Supreme Court on behalf of the appellant Sahodeo in the matter of Sahodeo versus State of Dharmistan. The Council seek permission to brief the facts of the case. Much obliged, your lordship. The state of Dharmistan is a part of Indian Union and have 100% literacy rate. Within the state, due to the prevailing norms, punitive measures are used as a measure to discipline students. On 14th August 2024, there was an incident in modern school Dharpur where the teacher Sahodeo disciplined a student for his misconduct of making fun of the teacher in the open class by smacking his head and pinching him under the right arm. Following the incident, the AMLO filed a complaint before the police station for teacher committing offences under Section 118 Clause 1 of BNS and Section 75 of JJ Act. In response to that, the appellant Sahodeo have approached the Honorable Court to quash the proceedings, and on the basis of the final decision and certificate awarded, an appeal has been filed before the Honorable Supreme Court of India. If your lordships are well versed with the facts of the case, the council seek permission to proceed with the arguments. Much obliged, your lordships. The appellant has come up with 4 submissions. The first 2 issues will be dealt by myself, and the last 2 issues will be dealt by my co-counsel, AG2. Proceeding to my first issue, my first submission is that the appeal filed under Article 134 is maintainable. It is humbly submitted before the Honorable Court that the Honorable Division Bench of the High Court have awarded certificate under Article 134A of the Constitution, which deals with certificate for appeal before the Supreme Court on its own motion or on the basis of an oral application made by the or on the basis of an oral application made by the parties. Article 134A of the Constitution is not an independent provision. Rather, it's an ancillary provision to Article 132 Clause 1, 133 Clause 1, and 134 Clause 1 Subclause C, as also stated in the case of State Bank of India versus SBI Employees Union 1997. If your lordships may refer to page 1, para 2 of the memo. In the present case, the jurisdiction of the Supreme Court to hear the appeal is maintainable under Article 134 Clause 1 Subclause C, which deals with certifies under Article 134A that the case is a fit one for appeal to the Supreme Court. Article 134 Clause 1 Subclause C of the Constitution deals with in regard to criminal matters, an appeal can be filed. But for filing an appeal under Article 134 1 Clause C of the Constitution, it should involve certain substantial question of law. And in the present case, there exists a substantial question of law in relation to, when we define the term substantial, it means that there has to be a difference of opinions of courts on the same issue. And the decision has not been dealt by the Honorable Supreme Court of India. In the present case, the substantial question of law is in regard to interpreting the child rights, its dignity, safety, while also maintaining the educational institutions and without criminalizing the reasonable disciplinary measures taken by teachers. The present case is also of a general public importance. In the present case, when we discuss the issues of a general public importance, as education is considered to be a very vital component in the child's life. So as to how the disciplinary actions taken by the teachers is to be dealt is a general public importance matter. Further, while the cases were going on before the single judge bench or division judge bench, there were media trials going on with the matter. So it is also important as to how the media should report these proceedings and should not lead to distorted media reporting is also a concern of general public. Therefore, the matter is of a general public importance. Further, the matter, there exist a rare and exceptional circumstances as well, as this matter is not only going to decide as to how, in the present case, the rights of the parties are to be disposed of, but it is also going to decide as to how it's going to set a future precedent as to how the disciplinary actions taken by the teachers are to be dealt with in the future. Therefore, it is submitted before the Honorable Court that the appeal filed under Article 134 Clause 1 Subclause C of the Constitution is maintainable. If your lordships do not have any further questions with regard to issue 1, the council seek permission to proceed with the second issue. Much obliged, your lordship.
What
Your lordship, your voice is not clear. Your lordship, shall I proceed with the second submission? Assuming the silence of the Honorable Bench, the Council proceeds with the second submission. My second submission is that the proceedings in the lower court should be quashed. It is humbly submitted before the Honorable Court that the High Court, under Section 528 of the Bharatiya Nagrik Suraksha Samhita, has the inherent powers to quash the proceedings, to prevent the abuse of the powers of the court, and to ensure justice prevails. As also cited in the case of State of Haryana versus Bhajanlal, 1992, where the Honorable Supreme Court have laid down certain pointers, if fulfilled, then the High Court can quash the proceedings under Section 528 of the Bharatiya Nagrik Suraksha Samhita. If, in the present case, if it is being established that there does not exist any prima facie offense, then the High Court can quash the proceedings. And if the allegations are of such nature that no prudent person would conclude the offense is being concluded, the Honorable High Court can pause the proceedings. In the present case, the essentials of Section 118 Clause 1 of the Bharatiya Nyaya Samhita and Section 75 of the JJ Act is not being fulfilled. Firstly, when we discuss about the essentials laid down under Section 118 Clause 1 of BNS, it deals with that there has to be hurt caused to the another person. As per the definition of hurt laid down under Section 114 of the Bharatiya Nyaya Samhita, it includes that there should be bodily pain, disease, or infirmity. In the present case, it is humbly submitted before the Honorable Court that the child does not have received any kind of bodily pain. Further, the court in the case of Rajan versus Sub-Inspector Police held that when hurt of less serious nature is being inflicted, it cannot be forbidden because because of the reasonable chastisement of the child by a parent or by a school teacher, where the parent have given the authority to the teacher. And hurt in itself cannot constitute an offense until and unless the second essential is being fulfilled. The second essential under this section is that the hurt must have been caused voluntarily. The term voluntarily defined that there has to be an intention on the part of the teacher to cause hurt to the child. In the present case, the teacher acted with a bona fide intention. The act was not a premeditated act. The teacher acted only after there was a discipline. There was a misconduct on the part of the student to make fun of the teacher in the open class, and the teacher acted only after that. There was a bona fide intention to discipline the student and no malice, as the teacher, when acted in that situation, didn't want to commit any kind of offense under the penal provisions and was merely a bona fide act. Further, the teacher has been in the profession for the past 30 years and an unblemished record, which further the teacher is also a social activist, which proves that what the teacher did in that situation was not something when the teacher wanted to commit an offense per se. And also, in the modern school Dharpur, there has been a tradition for the past 80 years to use such kind of punitive measures on students to discipline them. Even there are societal norms wherein it is being observed that such kind of measures are being observed and such kind of measures are being used to discipline students. Therefore, what the teacher did in that situation cannot be said to have been done with a voluntary purpose. Further, the third essential of this section clearly states that it should be done by dangerous weapons or means. In the present case, the conduct of the teacher was by pinching the student under the right arm and smacking his head. As per the definition of the word smacking, as it is not mentioned in the Black Law Dictionary or any of the penal provisions, but as mentioned under the Oxford Dictionary, it clearly states that smacking someone on his head is by a means of hand. And going by the definition of dangerous weapons or means, as the Act clearly states, should be of such nature that it should be an instrument which can be used for shooting, stabbing, cutting, or means of any fire, corrosive, explosive, heated substance, or something of that sort, which can cause the likelihood of a death in that situation. In the present case, there was a simple use of hand, which cannot be considered to be a dangerous weapons or means within the purview of the Act to say that the teacher has committed an offense under Section 118 Clause 1 of the Bharatiya Nyaya Samhita. Moving further, when we discuss the essentials laid down under Section 75 of the Juvenile Justice Act, the Juvenile Justice Act's essential clearly states that there has to be an unnecessary mental or physical suffering being caused to the child. Further, it is also to be ensured that there was any kind of an abuse, assault, neglect, abandonment towards the child from the person who is in charge of the child. In the present case, the teacher was in fact the teacher has the authority over the child and was in control over the child. But what the teacher did was not anything which is unnecessary physical or mental suffering being caused. As in the present case, the teacher's actions were merely on the basis of the misconduct on the part of the student to make fun of the teacher in the open class and not of a premeditative act. Further, the Act states that there has to be an assault, abandonment, neglect, or abuse. There was no there was there's no evidence as such that there has been neglect or abandonment done towards the child. Further, the act was not a premeditated act, which is necessary when we define the term assault as defined under section 130 of the Bharatiya Nyaya Samhita, which shows that there has to be gestures or preparations being done to ensure that there has been use of criminal force or force on the on the part of the teacher to commit the offense. Was a the act was on the basis of the misconduct and not something which was premeditated. Therefore, it can be said that the definition of the assault is not being fulfilled or the teacher have not committed assault under the section. Further, it can also be stated that there has been no abuse on the part of the teacher towards the child. When we go by the definition of abuse, the word abuse has not been defined under the section 75 of the JJ Act or under the Juvenile Justice Act. But as per the definition of the abuse, it can be observed from the definition of the abuse. If we look as per the dictionaries and everything, it is being stated that abuse denotes a negative connotation is being attached to it, and it denotes a greater degree of harm and referred to as a serious physical or emotional harm. But there has been no serious injury sustained to the victim, as the statements made by the teacher Sahu Dio before the single judge bench of the uh, High Court. And it can be stated that the term abuse has not been fulfilled in the present case. Further, the teacher acted under the authority of loco parentis.
If
The
you can
principal,
hold on for a second, if you can hold on for a second.
certainly, Your Lordship.
Now, you have submitted two aspects, mainly based on the statement that has been given by the teacher. First and foremost, how far that statement can be taken, we will come to that later. As regards the mental abuse or the mental suffering that could have been occasioned to the child, this is something that is enough to cause a kind of mental suffering in the child, especially when that happens in the front of the other students. Why do you say that Section 75 has not been attracted insofar? Because Section 75, there is no provision which would say that if it is justified or the act of the student required this to be done, any of these punishments could be inflicted on him. So, why do you say, or what substantiation do you have to contend that there has been no mental suffering?
Addressing the concern of your lordships, it can be stated that there have been no mental suffering being caused to the child, as the act of the teacher was done reasonably and in proportional into the classroom decorum, and cannot be said that the teacher acted with a
Sorry
the
to
teacher.
interrupt. Speaker 1, may please note you have only 5 minutes remaining.
Thank you, Court Master. And addressing that, it can be stated that the act was done in proportional to the act was done in proportional and was in reasonable act.
Section 75 does not even provide for such a stipulation at all, because there is no question of proportionality here. There is a provision which says that punishment for cruelty to the child. Does Section 75 anywhere provide that any kind of cruelty, or generally speaking, any of those prohibited activities is inflicted on a child, that could be justified by saying that there was a reason for it? You
Addressing
will
the
have to
concern of
point
your
it out. You will have to point it out from Section 75 itself.
Addressing the concern of your lordships, when we discuss the section 75 of the JJ Act, the intention is necessary. As when we discuss section 75, the word intention has not been mentioned per se in the act, but
Yeah.
in such cases wherein the offenses are of grave nature, the intention is difficult to prove. It has been presumed.
Speaker, please hold on. Where is the element of mens rea in section 75? You point out the element of mens rea and the definition of section 75, as my brothers pointed out.
Your Lordship, when we discuss, the section 75 per se does not mention the word intention. But when we see whether or not
then how can you say that there shall be an element of intention to constitute the offense?
Your Lordship, when we discuss as whenever an offense is being committed, the two essentials of an offense include that there has to be an actus rea and mens rea. In the present case, when we observe whether or not in the section 75 there's intention or not, in such kind of cases where mens rea is difficult to prove, the framers of law has implied that there is mens rea. And in the present case, the teacher acted with a bona fide intent to discipline the student and does not commit any kind of an offense under the penal provisions.
Since you said that, what do you understand by the term strict liability? A strict liability offense.
Your Lordship,
or an absolute other category, which is an ancillary category known as the absolute liability.
Your Lordship, addressing what do we mean by strict liability? Strict liability basically refers to as just a second, Your Lordship. Strict liability is basically a tort law principle that holds a defendant responsible for the damages or injuries caused by their actions or products, even if we are not at fault. It is also known as no fault liability.
Does it have any relevance here, or is it because something that falls totally in the realm of tort, it has no applicability, or are there strict liability offenses which could be pointed out in the criminal law realm also? I can give you two examples: Food Adulteration Act or offenses against children.
Your Lordship, addressing your concern, strict liability principle is also applicable in the criminal law as to hold that someone is guilty of a crime if they commit the act regardless of their intent. This
Is
means
75 one that would fall within that bracket of strict liability?
Your Lordship, when we define the term as to cruelty for punishment of the children, it cannot be said in the present case that the principal would fall under the strict liability per se, as also the teacher are under the principle of loco parentis, wherein the teachers have the authority over the child to discipline the students, and it is an implied or an express consent given by the parents itself to discipline the students. So it can be said that the strict liability principle cannot be per se be held under the section 75 of the JJ Act.
We may have to read all these aspects regarding permission granted by the parents and disciplining into section 75. Can it be possible? Can it be read into it? And further, if the section does not envisage a mens rea as such, can mens rea be read into a section when the statutory intent is very clear?
Your Lordship.
Speaker 1 may please not. You have 1 minute remaining.
Thank you, Courtmaster. Your Lordship, addressing your concern, when we discuss as to mens rea is being important element or not, when we discuss these offenses and the principle of loco parentis. Your Lordships, when we see the relationship of the teacher and student, in that scenario, we need to observe these offenses as to be applicable on the part of the teacher from the authority the teacher has in the classroom, wherein there have been chaoses, and to maintain those chaos, the teachers are under an authority wherein they can discipline
Then the
students.
question is, can we carve out from section 75 the teacher-student relationship, or does section 75 permit that? Or does even the act envisage any carving out of the teacher-student relationship as an exception to the section 75 requirements?
Addressing the concern of your Lordship, section 75 per se does not carve out the teacher-student relationship. But your Lordships, when we define the term cruelty as per the essentials laid down, your Lordship, the essentials are not being fulfilled in the first place to held that the teacher is liable under section 75. There was
Speaker
no
1
assault.
may please not. Your allotted time is over.
Your Lordships, if you allow extension of 20 seconds, I would like to wrap up my arguments.
Subject to what my senior brother Justice Babu would say. Sir, can we grant her 2 more
Yes.
minutes? Yes, yes, sir.
Please,
Yes, sir.
please.
Your Lordship, addressing the concern, the essentials of Section 75 is not being fulfilled. When we define the term cruelty as per the essentials, there was no unnecessary physical or mental suffering being caused to the child. And also referring to the case as being referred by the single judge bench of the High Court, the Sindhu Sivdas versus State of Kerala. In that case, the court highlighted then when such disciplinary measures are taken by teachers towards the students, it cannot be said that the teachers acted unnecessarily. Further, your lordships, when we define the term abuse, it denotes a greater degree of harm being done. In the present case, there have been no serious injury sustained to the victim. And the teachers also have the authority of loco parentis. Your lordship, there was also a case in the Kerala High Court. The name of the case is Matthew E.T. versus State of Kerala. Your lordship, in this case, the similar situation occurred. There was a music teacher who disciplined the student by pinching him under the right arm and smacking his head. In this case, the court clearly laid down that such kind of actions used by the teachers cannot be said to have committed any offenses under the penal statutes. Further, your lordship, there's also been cases when it has been said that the use of cane by the teachers cannot be considered to be offenses being committed in the penal statutes. In the present case, there was a mere use of hand on the part of the teacher to pinch the child and smack his head, where the student have not suffered any kind of serious injuries to constitute an offense under the BNS, Bharatiya Nyaya Samhita, or the JJ Act. Therefore, it is submitted.
Is injury mandatory or is injury required to constitute the ingredients of the offense under 75?
Yeah.
Is
Your Lordship,
injury required?
Your Lordship, can you please repeat the question?
No, is injury required to constitute the ingredients of the offense under 75?
Certainly, Your Lordship, when we discuss
Sorry,
as
where
to
does it say? Where does it say?
Your Lordship, when we define the term abuse being done to the child, or in any sort, when assault is being done to the child, it denotes a certain kind of harm must have been done to the child to constitute an offense under Section 75.
For which injury is required? Show me, show us. Where does it say injury?
Your Lordship, going by the term,
Pardon?
Your Lordship, addressing your concern, the term abuse itself denotes a greater degree of physical or emotional harm being done to the child. In the present case, there have been no serious injuries in regard to physical or mental, which can be said that the Section 75 of JJ Act.
A minimal mental suffering is required to constitute the offense. Is it not?
Certainly,
A minimal mental suffering is required to constitute the offense under Section 75.
Your Lordships, certainly not, Your Lordship. When we go by the definition of, as the term abuse has not been defined under the penal statutes, but as going by the term abuse in referred to the dictionaries, it clearly states that there has to be a greater degree of emotional or physical harm. Further, Your Lordship, as to the teacher has committed the offense, we need to look onto the tradition used in the schools. The modern school Dharpur, wherein the incident occurred, Your Lordship, there has been a tradition for the past 80 years to use such kind of a measures.
Speaker one may please not. You are allowed. The time is over.
If your lordships may allow an extension of 20 seconds, I want to complete this statement.
Better finish within 20 seconds. See, the
Certainly.
tradition has nothing to do in criminal, penal provisions. Tradition has nothing to do.
Your Lordship,
Tradition of your school has nothing to do with it. Nothing to do in criminal, the penal provisions.
addressing the concern of your lordship, when we discuss, certainly your lordship, traditions are not something which is to be discussed when we discuss the penal provisions. But when we are trying to ascertain whether or not there was an intention on the part of the teacher to commit the penal provisions, it is being stated that what the teacher did was a common measure used in the society, used in the school for the past 80 years to discipline the student, which proves that there was a bona fide intent on the part of the teacher to discipline the student, which cannot constitute an offense under these criminal provisions.
Then we may have to conclude that the school has been indulging in these criminal acts since the last many decades, at least from the date from which this act came into being, because it has been made a crime. Whatever the school has been doing since so far has now been made a crime, and they are continuing to indulge in it.
Certainly not, your lordship. the state of Dharmastan has a 100% literacy rate. Further, the teachers have the authority of principle of loco parentis to discipline students, and the tradition, as being said, it is seen as a measure wherein to discipline students in an effective measure. That the students are disciplined, which cannot be said that the schools are per se committing an offense for the past 80 years, Your Lordships. And RT Act, when we discuss the provisions as to when we discuss the use of corporal punishment per se, Your Lordships, RT Act is not a punishable RT on a penal statute, Your Lordships. It discussed about disciplinary actions which can be taken. And in the present case also, if such kind of measures are being taken, it cannot be said that the penal offense, the penal provisions can be attracted in the present case, Your Lordships.
There's a lack of
And
constitutional literacy. There's a lack of constitutional literacy. There's a lack of
Certainly not.
constitutional literacy in your case.
Certainly not, Your Lordships. When we discuss the term corporal punishment, Your Lordships, in India, the term corporal punishment per se have been defined under the Juvenile Justice Act, Section 2, Clause 24. But further, Your Lordship, under Section 82 of the Juvenile Justice Act, which defines as to the child care institutions to be made liable for corporal punishment, Your Lordship, schools are not included within the purview to be made liable, as it also shows the intent of the parliament or the legislature that when they enacted the law, they knew that the teachers under the authority can discipline students, and they were kept out of the purview of the act. And the RT Act is not a penal statute. Further, it can be said that the teacher is not liable as per the penal provisions. If Your Lordships does not have any further questions regarding the submissions made, I would like my co-counsel to make her submissions. Much obliged, Your Lordship. It was an honor arguing before this court.
Good afternoon, Your Lordships. If Your Lordships do not have any doubts regarding the issues dealt with my co-counsel, counsel seeks permission to continue with the remaining issues.
Yes.
Much obliged, Your Lordships. Your Lordship, the third issue in the present case is that the decision of the Division Bench of High Court should be overturned. For Your Lordship's convenience, I'll give a gist of my argument. Firstly, there is an error in the rationale given by the High Court. Secondly, teachers' actions do not violate Section 17, Clause 1 of the RT Act. Thirdly, the teachers' actions are not violative of the principles that are enriched under UNCRC. The appellant humbly submits that the Honorable Division Bench has errors in its reasoning by misapplying the legal principles, that disregarding the socio-educational realities of Dharmsthan and setting aside the precedent that criminalizes necessary classroom discipline. The judgment fails to distinguish between the systematic abuse and the reasonable corrective measures, Your Lordship, thereby undermining the authority of an educator and threatening the integrity of the education system. Even the government committee report on student discipline 2023, as mentioned in the Moot Court proposition, has categorically recognized that discipline in Dharmsthan school is aimed at creating a structured learning environment and fostering self-discipline in students. It can be considered from the fact that Dharmsthan holds a literacy rate of 100%. However, the Honorable High Court has failed to acknowledge that context and instead adopted an approach that equates any disciplinary actions with corporal punishment. By doing so, the judgment disregards the ground realities of the classrooms, whereby teachers must exercise reasonable authority to ensure effective learning. The single judge bench, in its reasoning, has correctly mentioned the Guru-Shishya relationship, Your Lordship, considering the reality of the state and how the authority of the teacher is needed to be respected. And division bench has completely overlooked this reasoning of the Honorable Single Judge bench. Furthermore, the division bench has relied on generalized conceptions about corporal punishments, which are being specific facts of the case. The appellants had, with an unblemished record spanning over 3 decades, merely engaged in a minor corrective measure that allowed that to with the intent of disciplining the child, and was no harm and no intent to cause harm, no excessive force, and no evidence of physical or psychological distress suffered
Since you
by
mentioned this Guru Shishya relationship, what exactly are the parameters or what exactly are the mandates under which this relationship, if at all it existed at some point of time, used to be carried on? Do we have any idea as to how this was carried on?
Your Lordship, considering it to even if considering the story to a methodology, these are considered to be in a state that how the people should be, how the people and how the customs of a society should be framed. That in the present case is the authority of the teacher is to be respected by the students. Your Lordship.
That means what?
Can the honorable bench repeat the question?
I'm not clear as to what you were pointing to, because since you mentioned about this Guru Shishya relationship, because it has rightly been pointed out as an inherently hierarchical setup where the respect for the Guru is something that is commanded through his brutal and often inhuman ways or inflicting injury on the child. So, what is the basis even for pointing out this Guru Shishya relationship or even the Ekalavya story? What is the
Your Lord,
relevance of all these things when we live in an era where you have the specific United Nations Charter and also more than two statutes made by our own parliament? Specifically, maybe this type of Guru Shishya relationship and the hierarchical setup was intended to be done away with once and for all finally. How do you bank on them again?
Your Lordship, it is in respect to the obedience of students towards a teacher and how the authority of a teacher
What are
in a
the
society.
parameters of obedience, madam? What are the parameters of obedience? What do you call as obedience?
Your Lordship,
Serviality, touching at the feet of the teacher. Are all these aspects which could be termed as matters of discipline? One
your
teacher
Lordship,
might insist that the student should come and touch his feet every morning. Can this be discipline? This may be
your
discipline of a very remorseful kind.
Your Lordship, these are the methods that a student shows how he respects the authority of a teacher and
Not
how
at
the
all
how,
intended. Not at all intended in this welfare state, 21st century state at all. They can have their own weird ideas of mythology, and the teachers can have it, but it cannot be implemented on students, overlooking the specific provisions of law.
Your Lordship, these represent how there are the roots of
It
Indian you
represents
how
nothing. It represents nothing, madam. At least in a court of law, it represents nothing. It may be mythology, may justify some kind of a reverence to it. Beyond that, cannot be used in a courtroom. Anyway, at least you should produce some materials so as to show that mythology and the concepts therein can be relied on. There are plenty materials now available. If you can look for them, you will find enough.
Your Lordship, addressing the concern of your Lordship, it depends upon the only part of the story that matters is that how a student go to an extent of respecting the authority of our teachers. That was the gist, or according to which the single judge bench has stated their decisions, and it states that in the roots of the Indian culture that owes that the authority of a teacher is must to be respected. When the threshold to be defined that they have a good intention to it,
Then
and
do you say that the concept of Indian culture and the Guru Shishya relationship contradict the principles as laid down by the United Nations in its charter, which you were just, I think you are proceeding to that. You will be submitting on that.
indeed, your Lordship,
UNHCR.
yes, sir.
Yes, go ahead.
Your Lordship, it is further submitted that the Honorable Division Bench has erred in holding that the appellant's action contravenes Section 17, Clause 1 of the RT Act, which prohibits corporal punishment in school. The ruling fails to distinguish between reasonable discipline and punishment, therefore misapplying the statutory provisions. Your Lordship, across jurisdictions, minor disciplinary measures have been recognized as legitimate tools for maintaining order in classrooms. The
Which
U.S. Department
jurisdictions, madam?
Your Lordship, the Council wants to mention that even the U.S. Department for Educational Policy on Student Discipline makes a clear distinction between excessive punishment and proportionate corrective measures. Similarly, the countries like Australia, reasonable disciplinary measures are permitted within educational
Can you point
institutions.
out one single instance from these jurisdictions which permit a corporal punishment, just like that was inflicted by this teacher in the as against the student? Just one provision in any of these jurisdictions regarding physical abuse or physical assault on the student. One provision from any of these jurisdictions.
Your
Specific.
Lordship, Your Lordship, the authority of the authority of U.S. Department on Educational Policy has cited that there should be a clear distinction between the disciplinary measures, and there should not be excessive punishment caused to the child, which
These are all
says that.
speaking on general terms might not help, madam. You may have to be specific. So if you are relying on United States or Australia or any other legal system so as to substantiate the contention, point out a provision which would justify the use of physical
Yes.
abuse,
Corporal punishment.
corporal punishment.
Your Lordship, the Council is not aware of any one instance, but when the Council will be further moving to the UNCRC issue, I'll be dealing with how even the principles of UNCRC recognizes that there should be a disciplinary measures to be dealt in the classes.
Yes.
Indeed, Your Lordship. Your Lordship, and Article 28, Clause 2 of the UNCRC requires school disciplines to be administered in a manner which is consistent with the dignity of the child. However, the treaty does not categorically ban all disciplinary actions. Instead, it recognizes the need for proportionate balance and non-abusive correction to the measures that effective learning should be there in effective learning should be there. Moreover, even the principle of best interest of the child, as enriched under Article 3 and Article 5 of the UNCRC, supports the notion that teachers must be empowered to instill discipline when it is done in a reasonable and non-abusive manner. The Honorable Division Bench has misapplied the international law by failing to harmonize these provisions with the realities of the classroom management, Your Lordship. If, if as my learned co-counsel has already pointed out that the section 82 of the JJ Act excludes the teacher from childcare institution, as it can be understood that the provision that has been taken in furtherance to Indian Union's commitment to UNCRC has an intent that physical punishment can be inflicted upon a child when they are within the ambit of being a disciplinary measure, Your Lordship. It is therefore humbly submitted.
Didn't understand that. You may have to explain that part of it a little bit further. How do you justify that UNCRC has been excluded when it comes to a teacher, just entitling him to inflict a corporal punishment?
Your Lordship, addressing your concern, Article 3 and 5 talks about the best interest of the child. And these conventions do not hold upon a binding obligation upon Indian Union. What holds a binding obligation upon Indian Union are the legislature that it enacts in furtherance to its commitment to these, as mentioned under Article 253 of the Constitution.
If that is so, you may have to explain out the position in Vishakha case, by which the Posh Act was enacted, singularly basing on an international convention, or the Supreme Court decision in MV Elizabeth versus Harvan Investments, where it has been specifically said that lacunas in Indian law could be plugged using the international common law on the point. So why do you say that there is a need for a statute to be enacted and UNCRC is beyond the purview of the powers of the court to look into when it comes to plugging the lacuna in local law?
Your Lordship, as the Honorable Bench mentioned about the case of Vishaka with the state of Rajasthan, it dealt with how the prevention of the sexual harassment is to be dealt at a workplace, as there were no already existing provisions regarding that. But when in the present case it comes to there are existing provisions under the RT Act and the Juvenile Justice Act that has been enacted under the Indian Union's commitment to the UNCRC principles. Now, what holds a binding?
So while we interpret and understand these two legislations, wouldn't it be quite natural for the court to look into the UNCRC convention based on which these acts were enacted for the purpose of understanding the statement and objects and reasons and the reason as to why these statutes have been enacted, and take cue from those conventions to interpret these provisions or these statutes?
Your Lordship, when it comes to international obligations, the laws in the Indian Union society are to be framed in an order that it deals with the societal conditions of the Indian unions too. As in the present case, Juvenile Justice Act has excluded teachers under the ambit of Article Section 82, as it does not want to include the teachers, as they mean that disciplinary actions can be permitted in the present case.
Is that a justification for inflicting corporal punishment is the only question.
Your Lordship, it is not a justification.
What is it that the teacher has been exempted from the charge of a? What is it that
Your,
the
Lo-
teacher has been exempted from?
Your Lordship, Section 82 of the Juvenile Justice Act states that when the authority of a child is given to a childcare institution, and the definition
So
of a
what purpose such an authority is given to you? Eh? So do you think that the teacher has been given an authority to inflict corporal punishment? Then what is the intention of the JJ Act? What
Your
is
Lordship,
the essential intention of the JJ Act?
Your Lordship, if the council continues with the
Some of the
submission,
portions in the IPC, JJ Act has been enacted with a specific intention, essentially to protect the basic dignity and humanity, basic dignity of the children. That's
addressing
the essential intention of the statute.
Your Lordship, the aim of the Juvenile Justice Act is a child welfare. As the council was already stating that even when we define the word child care institution, that has been defined under clause in Section 2, Clause 21 of the JJ Act, which excludes teacher from its ambit, which states that the teacher cannot be held liable under the corporal punishment, as mentioned in the Juvenile Justice Act, Section number 82, which states that the child welfare can be done when there are disciplinary actions being inflicted upon the child, when they do not stand to be abusive or violent. As in the present case, Sahudeva has inflicted a disciplinary measure which do not stand to be a punitive one. If your Lordship do not have any doubts regarding the first issue raised, Council seeks permission to continue with the remaining issues.
Speaker, I have one question.
Indeed, Your Lordship.
At present, there have no exception for the teachers or for the parents in the Juvenile Justice Act Section 75. Do you think that there should be some exception to the teachers and the parents who are the well-wishers of the child, so that they can impose some minor forms of punishment? Such an amendment, do you think that it is appropriate? Because the values are to be developed during this childhood. A child is molded in such a fashion that he should be a good human being. So whether you think that some amendment is required in Section 75, or whether it is to be continued as such, as it stands now. What is your view?
Your Lordship, reasonable punishment can be inflicted upon a child until and unless they do not turn out to be violative. As in the present case, looking at the background
Sorry
that
for the interruption. Speaker 2 may please not. You have only 5 minutes remaining.
Thank you, Court Master. As the background of state of Dharmsthan holds that when the disciplinary measures have been enacted throughout the schools, it holds a literacy rate of 100%. It proves the point that when disciplinary measures are enacted in the schools, the future of the country goes to a developed side as they have a literacy rate of 100%, as mentioned in the Moot Court proposition, Your Lordship.
Whether the intention of the act is to prevent abuse of child by some other person other than the well-wishers, such as the parents and the teachers. So whether there should be an amendment to the extent that the well-wishers of the child, who are the none other than the parents and the teachers to some extent. Do you think that it is whether you thought of such a situation, whether it is required in your view?
Your Lordship, the word well-wishers have been clearly defined under the Juvenile Justice Act, and the Juvenile Justice Act is clear in its interpretation as when it says that well-wishers of the child can, as it can be inferred from the provisions mentioned, that parents and teachers can inflict some amount of physical punishment to the child when they are the well-wishers and they have done in a non-violent manner that do not cause any mental suffering or physical punishment to the child, Your Lordship.
Yes, proceed.
Indeed, Your Lordship. Your Lordship, Council seeks permission to continue with the remaining issues. Your Lordship,
Yes, proceed.
Indeed, Your Lordship. The issue in the present case is that there is a need for judicial guidelines to ensure media reporting. For the convenience of Your Lordships, I'll give a gist of my arguments. Firstly, distorted media reporting infringes upon right to fair trial and violates the principle of natural justice. Secondly, the judiciary has the authority to frame guidelines in light of the domestic and international legal frameworks. Your Lordship, the right to equality under Article 14 and right to life and dignity under Article 21 guarantees every individual a fair and impartial, unbiased trial. However, when media sensationalization influences judicial proceedings, these constitutional safeguards do not come in hand. As trial by media disproportionately impacts the accused person, depriving of the presumption of innocence, excesses uh, uh, eroding his presumption of innocence and his access to fair hearing, and thus violating his Article 14 and 21 as constituted to him under the Constitution. Even the 200 Law Commission report specially acknowledged that excessive pre-trial publicity creates a bias of the accused, thereby violating the fundamental rights of the pre-trial. The Honorable Court, in the case of Arundhati Roy, is also of the same opinion that excessive pre-trial publicity creates a bias in the public and violates the principle of natural justice and Article 21(14) given to the person. Your Lordship, public faith in judiciary is a foundation of democracy. However, unregulated media narratives create a perception that judicial outcomes are dictated by public sentiments rather than the rule of law. Sensationalized reporting distorts the fact, misrepresents judicial proceedings, and places undue pressure on the courts to deliver decisions that align with the public expectations rather than legal principles. They even blur the
Speaker
line
Thume,
between.
please not. You have 1 minute remaining.
Thank you, Court Master. Summarizing my arguments till now, as media reporting violates fair trial, it violates Article 14 and 21 that has been granted in the Constitution, and it even erodes public trust in an institution like judiciary, which is needed in a democracy.
Is there a right to freedom of press in the Indian Constitution?
Indeed, Your Lordship, the right to freedom of press is under the 19(1)(a) of the Constitution, which is freedom of
Yes.
speech and expression.
When two freedoms conflict, how do we balance that?
Your
What is
Lordship,
the procedure as laid out by the Supreme Court in the catena of decisions as to when it comes to balancing two fundamental rights that are at loggerheads with each other?
addressing the concern of Your Lordship, as there have been tests laid
Speaker
down.
Thume, please not. You are allowed. The time is over.
Your Lordship, can I get an extension of 2 minutes to summarize my issue and answer the question of the Honorable Bench?
You have not to answer that question. How to
Your
balance
Lordship,
fundamental freedom.
I will be answering your question. I'll be answering the question, Lordship. Based on the legal documents provided, the key principle for resolving conflicts between two fundamental rights are hierarchy of rights. If the Constitution establishes a clear hierarchy between the conflicting rights, the right with higher status will prevail. As in the present scenario, when we talk about balancing the rights, even the public holds right to information, media holds its right to speech and expression, and public trust in an institution or like judiciary is to be balanced. On the other side, if we take that there are accusations that the right to fair trial is being violated. If we take a balance in the present case, it is very clear that
No, using the very same rationale of balancing or hierarchy, how do we place these rights that are in conflict here? What is the hierarchical order in which you would personally place these rights? Which one would precede the other, or which one would succeed the other?
Your Lordship, all these as being fundamental rights has been placed on the same pedestal. But when it comes to public interest, then we will judging the scenario by the public interest in the present case, as the public has the right to know about the judicial proceedings, and public trust in an institution like judiciary is to be maintained. There comes the need of judicial guidelines to be framed in the present scenario, Your Lordship.
Does that override
How do you balance in the case of Article 19 and Article 21?
Yes.
Can the bench repeat the question?
the article, see, two fundamental rights, Article 19 and Article 21, and then how do you balance when they come
Your,
to
Lo- Your Lordship, if we restrict the media reporting, Article 19(1)(a) on the face of it is getting violated. When it comes to Article 21 of the Constitution being violated, the Council accepts the scenarios that there are instances when the right to dignity and life of the accused is distorted by media, but that cannot be the provision of restricting and putting guidelines upon media. There we know that there is a need for judicial guidelines, as there are, because even if the right of the accused is getting violated, there are remedies that can be put forward, and there exists a robust legal framework that the accused can go in, be it the Contempt of Court Act, defamation, and even the Press Council Act provides all these remedies to the accused if he feels that his rights have been violated. Putting guidelines to restricting media do not stands to be a provision that can be taken in the present scenario, Your Lordship.
Have you seen the recent Kerala High Court full bench judgment?
Yes, brother was, one of the members in the bench. Yes.
Wherein Kaushal Kishore, there is a latest judgment in Kaushal Kishore, wherein the Supreme Court had attempted to balance these rights. Anyway, you can read through Kaushal Kishore, and subsequently there is a Bombay High Court decision in Kunal Kamra, wherein this matter has been looked into in detail.
Council will go through the suggestions by Your Lordship. The Council seeks permission to continue with the prayer if the bench do not have any further questions. Indeed, Your Lordship. Wherefore, in the lights of fact presented, issues raised, argument advanced, the authority cited, the Council, on behalf of the appellant, humbly pays before this Honorable Court to adjudge and declare that the proceedings in the lower court be caused, that the decision of the Division Bench of High Court of Dharmasthan be set aside, that there should be judicial guidelines for responsible media reporting, and or pass any order, direction, or relief that it may deem fit in the interest of the justice, equity, fairness, and good conscience. For this act of kindness, Your Lordship, the appellant shall duly bound forever pray. It was in honor, I think, this honorable bench.
Yes.
With the judge's kind permission, shall we start the respondent side arguments? The first speaker of the respondent may begin.
Council seeks permission to approach the dais.
Yes.
Greetings to the honorable bench. This is the council on behalf of respondent in case of Sahu Dio versus State of Dharmasthan. May it please this honorable court, the council seeks permission to refer to this honorable bench as collectively as your lordship and individually as your lordship.
Yes.
Your lordships, counsel for the respondent would be taking 45 minutes in total of this court's precious time. The counsel would be taking 17 minutes. My co-counsel would be taking 23 minutes, reserving 5 minutes for the rebuttals. With the permission of your lordship, counsel would like to state the issue in the present case. The counsel for the respondent has prepared 3 issues in the present matter, which are: issue 1, whether the act of Sahu Dio of smacking and pinching the child constitutes an offence. Issue 2 being whether the High Court under Section 528 of Bharatiya Nagrik Suraksha Sanhita erred in quashing the criminal proceedings against the teacher. And issue 3 being whether the concept of corporal punishment is in accordance with the rights guaranteed under the Indian Constitution. The first issue would be dealt by the counsel, and remaining 2 issues would be dealt by my co-counsel. The council seeks permission from your lordships to present the submission for the first issue at hand. It is humbly submitted before this honorable court that the act of Sahu Dio of smacking and pinching the child does constitute an offence, and it can be established on 2 grounds. First ground being that inflicting of corporal punishment is against child rights, and the second ground being the actions of Sahu Dio constitutes an offence under Section 75 of Juvenile Justice Care and Protection Act 2015 and Section 17(1) of the Right of Children to Free and Compulsory Education Act 2009. With respect to the submission on the first round, your lordship please may refer to the memorial on page 1, para 1 of the pleading section.
Yes.
It is humbly submitted before your lordships that United Nations Convention on the Rights of the Child defines corporal punishment as any punishment in which physical force is used and is intended to cause some degree of pain and discomfort, however light. Most involve smacking, slapping, and pinching the child. Council would also like to draw the attention of your lordships on some important articles of this convention with respect to state parties' obligation. Your lordship, Article 19
Yes,
clearly
go ahead.
states that the government must do all they can to ensure that children are protected from all forms of violence, abuse, etc. by their parents or anyone else who looks after them. Article 28 2 states that the state authority should take measures to ensure that the school discipline is administered in a manner consistent with the child's human dignity and confronts with the present convention. Article 39 recognizes the right of the child to be treated in a manner that is consistent with the sense of dignity. And most importantly, Article 4 talks about how state parties must do all they can to make sure child can enjoy the rights recognized in the present convention by creating and passing the laws that promote and protect child's right. Your Lordship, it is pertinent to note that India has ratified to this convention back in 1992 and is one of the signatories to this convention. Therefore, it is becoming obligatory for India to take legislative and administrative and others measures to implement the rights recognized in this convention.
No,
It
there,
is hum
if you pause for a moment, taking cue from what Brother Justice Jayagumar was pointing out, all these conventions and all these laws which have been made so as to protect the interest of the child differentiate between certain groups of people who are genuinely interested in the welfare of the child, like, for example, the parents and the teachers. And these offenses that are envisaged from which the child should be protected are done by others, not by these persons who are well intending persons. So, that is there on one side. Secondly, we have this great Guru Sishya Parambara, whereby we have our own way of disciplining children and our own way of bringing them up. So, even if we are a signatory to UN resolutions and we have created laws in accordance with it, this is the most prominent norm based on which we will have to interpret these provisions, because these cannot be interpreted so as to take away the rights of the parents as well as the teachers and the well-wishers of the child, because that's a nebulous term which would take in maybe his relatives and all those well-wishers. So the well-wish, as far as well-wishers are concerned, these rules doesn't apply. They are entitled to use reasonable, even corporal means so as to discipline the child for its larger benefit in life. That is the contention that, or that was a proposition that was suggested. So none of these reliance on these UN conventions would merit any consideration if that is the basis on which we have to look into it. And that is a valid point also.
Your Lordship, Article 1551, Clause C of the Indian Constitution states that states shall endeavor for the respect for international laws, treaty, and obligation. Your Lordship, even in the case of Vishakha versus State of Rajasthan, has held that the international instruments can be very well be the part of Indian law as long as they're not inconsistent with it.
Correct,
And
correct. That exactly is the point. That exactly is the point. As long as it is inconsistent, we have our own system of bringing up children, and we have succeeded and reached this level by following that system. So any international norm that is brought into the Indian legal system will be tempered by our own practices and our own customs and our own understanding of the principles. So we understand these principles in such a way that yes, children are entitled to be protected from abuse and exploitation and corporal punishment, but only by others, not by their well-wishers. Well-wishers are entitled to do it as long as it is reasonable and justified.
Your
So that
Lordship, this
that
can
is a large bracket under which we will be approaching all these UN conventions and other principles that have been brought in. What
indeed, Your
prevents us
Lordship.
from doing that?
Indeed, Your Lordship, but this child rights has been recognized and has evolved from and has evolved since the decade back. And the same thing cannot be applied in the era where even the animals have the right to be protected from cruelty. Our children cannot be below animals, and we cannot be of the notion that the children have no right for their personal dignity. So So, in light of that, your lordship, right to Free and Compulsory Education Act 2009 and Juvenile Justice Care and Protection Act are the example of the domestic statutes designed to protect the child's right. Your lordship, thus, any interpretation of legislative measures taken for the protection of the child must prioritize the best interest of the child and prohibits from all form of physical violence against the children and promote positive and non-violent discipline. If your lordship may please can refer page 3 para 8 of the memorial. It is submitted before this honorable court that according to National Charter for Children 2003, state is committed to protecting the child from all form of abuse. Article 9 of the charter talks about the affirmed commitment of the government to protect the children from all form of the abuse and including corporal punishment. And Article 9b underlines the responsibility of the state to take legal action against those committing such violation, and even if those are the legal guardians of the children. Therefore, it is respectfully submitted before this honorable court that the act of Sahudio in administering corporal punishment to Amlock violates the child's right. Consequently, the state is under the legal obligation to take appropriate action and enforce measures against the appellant. If your lordships are satisfied with the submission on the first ground, the council seeks permission to move to the second ground.
No, have you come across a judgment of the Kerala High Court in Rajan versus Sub Inspector of Police, where this aspect has been looked into in detail and has been succinctly laid down that if the act is not preceded by malice, it doesn't say mens rea, by malice, then the teacher or the father is justified in doing it.
Your Lordship, with respect to that, I would like to submit the case of Pramila Fregor versus State of Kerala, in which
No, have you seen this judgment in Rajan versus Sub Inspector of Police?
Indeed, Your Lordship, we have seen this judgment. With respect to that, I'm submitting that in this judgment of Pramila Fregor versus State of Kerala, these judgments have been cited, and the court has been of the opinion that the corporal punishment is outdated and is against the Article 21. That is, it violates the child's right, Your Lordship.
And the law as it stands now by the High Court of Kerala in Rajan versus Sub Inspector of Police is very clear. What is the dictum laid down there and what is the citation?
Pramila Fregor?
No, Rajan versus Sub Inspector of Police.
Rajan versus Sub Inspector of the Police is...
What is the dictum there and what is the ratio that has been evolved? It is one of the important cases on the point from the Kerala High Court.
Indeed, Your Lordship, but the decision
what is the ratio? What is the dictum?
When the student, that the court ruled that the teacher was in the process of disciplining the child, therefore the act of the teacher would...
No. It makes a distinction with acts that are done or preceded with malice.
Indeed, Your Lordship. But Your Lordship, we cannot subject the children to corporal punishment because it is violating their child's right to bodily integrity, Your Lordships. And Your Lordship, also we have to keep in mind the other evolving judgment of Pramila Fregor, where it has been ruled, this Rajan case has been cited and the court has ruled that the concept of corporal punishment is against the child's right to bodily integrity, Your Lordship.
Yes.
Your Lordship, it is submitted before this honorable court that the act of Sahudio constitutes an offence under section 75 of the Juvenile Justice Care and Protection Act. Your Lordship, section 2 clause 24 of the JJ Act defines corporal punishment as subjecting a child or by any person to physical punishment that involves the deliberate infliction of pain as a retribution for an offence and for disciplining or reforming the child.
Let's pause there for a moment. As a retribution for an offence. What do you understand by the term retribution?
For reforming the child, if the child has committed any offence, for reforming him.
Is that the meaning of retribution? It has to be, if it is done with a retributive intent, so as to punish him with an object of punishing him, or with the retribution as a objective, this would be illegal. As long as the retribution part is not there, The Juvenile Justice Act does not prohibit any reasonable act which falls beyond the scope of 75 or a cruelty to the child from being inflicted on it for its own well-being.
Your Lordship, we have to keep in mind Section 17(1) of Right to Education Act. It
No, we
completely
cannot. No, we cannot skip on from one act to another like that. If we are dealing with Juvenile Justice Act and you are specifically defining the term corporeal punishment, we may have to understand that term and ascertain as to whether the mandates or the elements meet the case at hand. So the question is there any element of retribution in what Sahu had did?
Your Lordship, we have to
Pikuan,
harmoniously.
I'm very sorry, but you may please note that you have 5 minutes remaining.
Your Lordship, we have to keep an harmonious construction of all the acts that are prevalent in the current scenario. Your Lordship, by applying the National Charter for Children, what is the aim of the legislature is to prevent the children from any form of the corporal punishment. Similarly, Section 17(1) says that the child should not be subjected to any form of the physical punishment. Thus, harmoniously construing all the acts, it cannot be said that the legislature was of any intent of allowing even reasonable punishment in Section 75, Your Lordship.
You have not answered the question raised by my learned brother. What's the element of retribution in the act alleged? Deliberate that, see, the element of mens rea is highlighted in the definition of corporal punishment. Deliberate infliction of pain as retribution. Deliberate infliction of pain as retribution. Is such an ingredient is there in the acts alleged? That's a question raised by my brother, Justice Shamkumar.
Your Lordships, Amlock did misconduct in the classroom.
That has nothing to do with this. Yes, proceed. Yes.
Since the act of the since there was misconduct on the part of the Amlock to discipline him, he could have used other corrective measures rather than informing corporal punishment on him. There exist other corrective measures such as counseling of the child, informing about the misconduct to the parents of the child.
Yes.
So, with light to that, Your Lordship, in case of Kishore Guleria versus Director of Education and Directorate of Education.
Cannot it be used, termed as an act done in good faith for the benefit of the child?
Your Lordship, the act of corporal punishment cannot be said to be in good faith or benefit of the child because, Your Lordship, the act of corporal punishment has a long-lasting effect on the well-being of the child. Your Lordship, there are a lot of reports that suggest that if the child is subjected to corporal punishment, there can be long-lasting mental effects. And also, Your Lordship, the child in the tender age cannot be made grown in the environment where the use of physical force is allowed, and because the child will grow with the intention that physical force can be used as an option if their wishes are not fulfilled.
That is where the opinion that was mentioned by Brother Justice Jayagumar assumes relevance. Because who understands the child better? Who is more concerned about the child's future? It can be the parents, the well-wishers, and the teachers. And they never, ever would do anything that would cause unreasonable pain on the child. They would do it with the purpose of a intent, with a good intention, so as to secure his future. Whereas it comes to others who are outsiders, who may not fall within the bracket of well-wishers, like parents or teachers, you may be right. They cannot do this. Like, for example, the caregivers, the institutions which are run by caregivers, they may not be able to do that. But when it comes to well-wishers, should we not treat them differently and their intentions, and rather respect their intentions for the fact that they are the best persons who are most appropriately situated to decide and also think in terms of the future of the child? We cannot go on a preemptive notion that they would be doing things that would detrimentally affect the child? Can we expect that any parent, or for that matter, any teacher, especially in our Guru Shishya Parampara, would do anything that would detrimentally impact the child's future? No. So they are only disciplining him for the purpose of understanding the rigors of life, the the character that he has to acquire when he wants to proceed further in life. So what is, shouldn't we be differentiating these two is the question.
Your
And
Lordship, if
yes, sorry, go ahead.
indeed, Your Lordship. Your
The
Lordship,
council, you may please note, you have 1 minute remaining.
Your Lordship, submitting on that, Your Lordship, please may note that if the use of corporal punishment is normalized, the child will become withdrawn and will exhibit an antisocial behavior, and will also can acquire a disdain and hatred towards their children, thus discouraging regular attendance and will increase the dropouts from the school. Your Lordship, due to the normalizing the use of force as a form of punishment, the children can learn that physical punishment is an accepted mode of compliance with one's wishes, and the violence would be forming an integral part of their life. The child has to be prepared for a responsible life in a free society in the spirit of understanding, peace, and tolerance, Your Lordship. Your Lordship, with respect to that, I would
Council,
be.
you may please note, your allotted time is over.
Your Lordship, I would like to submit my submissions here and would like to invite my co-counsel for remaining two issues.
Yes.
The council seeks permission to approach the dais.
Yes.
Much obliged. Good afternoon to the honorable bench. The council will be dealing with the second as well as the third issue. The second issue at hand is whether the High Court erred in quashing the criminal proceedings against the teacher under Section 528 of BNSS. The council seeks permission to proceed with the submissions.
Yes.
Much obliged. Your Lordship, the High Court of Dharmastan incorrectly exercised its inherent powers to quash the criminal proceedings against the teacher, as it has been well established in judicial precedents that the powers of High Court under Section 528 of BNSS, which was earlier Section 482 of CRPC, must be exercised sparingly and cautiously. Your Lordship, the Council requests your attention to page number 10 of the written submission of the pleading section of the respondents herein. In the matter of Munshi Ram versus State of Rajasthan, it has been held that the court has to cautiously use Section 482 of the CRPC, and such quashing of criminal proceeding cannot be done at a very initial and premature stage without even letting the police to investigate into the matter. Also, Your Lordship, in a plethora of cases, it has been constantly laid down that Section 528 of BNSS is an exception and not a rule. Your Lordship, firstly, I would like to show that how the single judge bench of the High Court of Dharmastan incorrectly exercised its inherent powers under Section 528, as the decision do not meet the tests specifically laid down in the provision itself. Your Lordship, it must be noted that the provision of Section 528 of BNSS specifically and explicitly states that High Court can quash the proceedings only to enforce any of its orders, to prevent the abuse of court, and to secure the ends of justice. However, Your Lordship, the High Court herein failed to secure the ends of justice by quashing the proceedings under Section 528 of BNSS 2023. Your Lordship, one needs to understand that there is no unlimited jurisdiction of High Court under this provision. It needs to be exercised only when continuation of a criminal proceeding would lead to a huge miscarriage of justice. But Your Lordship, the single judge bench herein, by preventing the proceedings from going on.
What can there be more than this? More miscarriage of justice more than this? Subjecting a person to an unnecessary trial, which would ultimately end up in his acquittal. Why should he go through the trial? Why can't the inherent jurisdiction as it exists in this court be exercised in such a case? Isn't there a situation which would warrant or justify the invocation of these powers?
Indeed,
What is
Your
the prima
Lordship,
facie basic case that has been put forth? If no basic case or prima facie case even has been put forth, why should he strand the trauma of a trial?
Indeed, Your Lordship. However, the Council humbly seeks to differ from what Your Lordship said because, Your Lordship, it has been incorrectly mentioned in the moot prop itself that injuries have been suffered by the victim. Your Lordship, even though not serious, or the petitioner may contend that the acts were minor. However, Your Lordship, the psychological effects and the allegation put forward by the put forward by the victim herein cannot be considered. Moreover, Your Lordship, the alleged provision of section 75 is attracted in the present case. Your Lordship, corporal punishment has been punished through
No,
the Indian
you cannot
statutes.
you cannot skip from one provision to another so easily. We are on the old 482, which is now on and BNSS section 5. I'm sorry again.
28, 28.
528, 528. We are on the jurisdictional question. So explain it a bit further. Why do you say that an exercise of this inherent powers is not justified in the facts and circumstances? Or just tell us generally, what is the law that has been laid down on the point which would justify the exercise of inherent powers?
Your Lordship, as far as the
We
scope of
have an
section
innumerable number of Supreme Court
Yes.
judgments. Can you just give us some?
Your Lordship, as far as the scope of Section 528 of BNSS is concerned, it has been laid down in a variety of cases, Your Lordship. If I may point out the case of State of Haryana versus Bhajan Lal, it has been pointed out that when it has been specifically laid down in the section itself, Your Lordship, that when the High Court thinks that a particular matter would be a futile exercise to proceed with a particular criminal proceeding. And if the materials placed before the court are so minute or trivial that it would lead to an abuse of the process of court, the court herein can exercise the inherent powers. However, Your Lordship, it has also been held in precedence of, I would like to point off, Your Lordship, the matter of Kaptan Singh versus State of UP. It has been clearly laid down that this provision and the powers guaranteed under this section is an exception and not a rule. Your Lordship, the High Court has to cautiously exercise these powers and cannot quash any proceeding at a very premature state. The High Court has to take note of any.
Please hold on, Speaker. Suppose if the complaint or the FIR does not disclose the essential ingredients of the offense, then what's the purpose in proceeding with the trauma or trial?
Your Lordship, the Council contends that the essential provisions
go to the first penal provision 118.1. 118.1 of the BNS. Do you think that the ingredients of the offense under 119.1 are satisfied in the facts revealed, facts alleged?
Your Lordship, Section 118.1 of Bharatiya Nyaya Sanhita talks about voluntary causing hurt by or grievous hurt by means of a dangerous weapon. However, Your Lordship, it can be well contended that the criminal proceeding or the FIR filed herein can be made by a layman if the provisions or the alleged evidences do not attract the provision of 118. It does fairly attract the provisions of 115 and 116, Your Lordship, as injuries have been caused. Moreover, Your Lordship, as far as the Juvenile Justice Care and Protection Act is concerned, in that statute also, Your Lordship, Section 75 of the Act is attracted, Your Lordship, because of the commission of a clear corporal punishment by the teacher herein.
You went through, in fact, you explained the definition of corporal punishment. And do you think that the ingredients of the definition of corporal punishments are there in the allegations made out?
Your Lordship, as far as the Section 2, Subclause 24 of JJ Act is concerned, corporal punishment means the subjecting of a child by any person to physical punishment that involves the deliberate infliction of pain as retribution for an offense or for the purpose of disciplining. Your Lordship, herein it can be fairly said that the petitioner who is taking the defense that he was doing this for the purpose of disciplining the child cannot be taken, because in the definition itself it has been mentioned that corporal punishment is a kind of physical punishment that can be inflicted for administration of discipline, Your Lordship. It is a physical infliction of pain, Your Lordship, which has been made in the present case, Your Lordship, by even if it's a minor injury, Your Lordship, the severity of injury does need not to be taken in this consideration, Your Lordship. The matter is of a social significance and public interest. Therefore, Your Lordship, corporal punishment has been banned and must not be exercised by any teachers in the educational institutions.
That is your opinion or a substantiation based on the legal tenets available?
Your Lordship, that is the contention of the council.
Yes.
If Your Lordships have no further questions, I'd like to move further with my submissions.
Yes.
Much obliged. Your Lordship,
one more question.
Sir, yes.
You referred to section 528 and 482. From which provision the High Court gets inherent powers? Under what provision the High Court gets inherent powers? Under what?
Your Lordship, under provision 528 of BNSS, the High Court has inherent powers to quash the proceedings.
Read that section. You read that section. Do you? Can you say that? Can you say that 528 or the old 482 confers inherent power to the High Court?
Your Lordship, Section 528 states nothing in this Sanhita shall be deemed to limit or affect the inherent powers of the High Court.
So 582 simply says that nothing in the code prevents the High Court from exercising its inherent power. So from where the High Court gets its inherent power?
Your Lordship, inherent powers are something which
482 or 522, I mean, in fact, 482 or 522 do not confer the inherent power. Inherent power to the High Court comes from somewhere else.
Your Lordship, inherent powers are something which comes to an institution or an establishment by virtue of its position. Your Lordship, herein the inherent power. Your Lordship, herein the inherent powers.
High Court being a court of record under Article 215.
Yes, Your Lordship.
Under Article 215.
Yes, Your Lordship.
So, High Court gets inherent power from Article 215. And 582 is not a, 582 says that CRPC is not a bar or BNSS is not a bar to exercise that inherent power. In fact, 582 doesn't confer the inherent power. Inherent power comes from the Constitution. Yes. I was just explaining it. Yes.
Indeed, Your Lordship. The Council seeks permission to proceed, Your Lordship.
Yes, please.
Much obliged. Your Lordship, one needs to understand that there is no unlimited jurisdiction of High Court under this provision. It needs to be exercised only when continuation of a criminal proceeding would lead to a huge miscarriage of justice. But Your Lordship, the single judge bench herein, by preventing the proceedings from going on, has failed to consider the social impact of the decision and concerns regarding the protection of a vulnerable child from corporal punishment. Your Lordships, the allegations in this case, including the physical harm of pinching and smacking, are serious in nature for a young child of tender age and cannot be dismissed at the very outset. Your Lordship, I would like to point to the case of Sindhu Sivadas versus State of Kerala, which the single judge bench herein relied in before giving the decision. Your Lordship, the factual matrix of the case of Sindhu Sivadas does not apply to the present case, as in the case of Sindhu Sivadas, there was only mention of a mere scolding by the teacher. Your Lordship, the case factual matrix do not meet, therefore this case cannot be relied on by the single judge bench of the High Court of Dharmastan. Therefore, Your Lordship, the court has to step in and determine the truth of the matter and culpability of the accused thereof. The actions described fall within the scope of corporal punishment and physical harm, which is a criminal offense under Section 75 of Juvenile Justice Care and Protection Act 2015. Your Lordship, in Sob Mittal versus Government of Karnataka, it has been held that the power under Section 482 of CRPC must be exercised sparingly with circumspection and only in rarest of rare cases. In the context of quashing the criminal proceedings or complaints under Section 528 of BNSS, the High Court must carefully evaluate whether the ends of justice would be served by exercising its inherent powers. Your Lordship, the court must evaluate all the materials that is available before it to proceed with the trial rather than prematurely quashing the proceedings. Your Lordship, the second limb of my argument deals with the fact that quashing of the criminal proceeding by the single judge bench herein did not meet the ends of justice but instead led to injustice for the child. Your Lordship, the very purpose of criminal law is to protect vulnerable individuals, especially children. When the High Court quashes the FIR prematurely, it deprives the child of the right to seek justice. Teachers, as custodians of children's well being, should be held accountable for any form of abuse, Your Lordship. By stopping this case at a very early stage, the court essentially undermines the child's fundamental rights. Your Lordship, the teacher student relationship involving corporal punishment raises critical issues of child protection, and such cases require careful judicial scrutiny to ensure that justice is served and societal values are upheld. Your Lordship, it must be noted that abuse in educational institutions is not a private matter, but a socially significant matter. And the single judge bench of Dharmastan, by quashing the proceedings, have failed to secure the ends of justice or discuss upon this inherently significant social matter. Your Lordship, child abuse is common in institutions and must be taken note of. The abusers herein abuse their position of power and authority to inflict harm upon the young ones entrusted to their care. Your Lordship, it would be wrong to focus only on the severity of injury, as herein the petitioners are contending that the minor acts of pinching and smacking the head cannot be considered as huge or grievous injury. However, Your Lordship, considering the cases of corporal punishment, even mild physical force on a child of young tender age can cause long-term psychological harm to the child. Therefore, the law must step in to prevent any forms of physical punishment in school, regardless of the severity of injury. Your Lordship, corporal punishment further creates an environment of fear in schools, which directly contradicts with the right of education guaranteed under Article 21A of the Constitution of India. Your Lordship, in the matter of Hasmukh Bhai Gokhal Das versus State of Gujarat, it has been held that corporal punishment can cause children to avoid schools, leading to higher dropout rates. Your Lordship, this case is not just about holding one teacher accountable, but also ensuring that every child has a safe environment to learn and free from threat or any kind of violence. Your Lordship, the single judge bench's decision herein would lead to normalization of corporal punishment and would undermine child rights. The social impact of not stopping corporal punishment is huge and strictly in contradiction to child rights. The court need to keep these consequences in mind and may continue the proceedings to recognize the child rights and prohibit all forms of violence. Your Lordship, now I would like to move to the third issue, which pertains to the outdated nature of corporal punishment and its growing irrelevance in the modern society and how the practice stands in contradiction to the rights guaranteed under Constitution of India. Your Lordship, it must be noted that the practice of corporal punishment infringes upon the bodily integrity and autonomy of a child, which are fundamental principles of UNCRC. Applying such outdated principles of corporal punishment in today's education system disregards the evolving understanding of children's rights. The traditional norms exemplified by Eklavya's story and analogy are no longer relevant in the contemporary society where respect for children's dignity and well-being must take precedence. Your Lordship, the first limb of my
Why
argument
do you
deal with
say
how.
so? Why do you say so? Because what is the basis on which you reach such a conclusion or you place such a contention? Because we have to understand and we have to implement the law in the society based on the mores of the society and its own traditions and its own way of understanding. This is a matter that affects the very delicate and very touchy subject of parent-child relationship or teacher-child relationship. Why do you say, or on what basis do you say that the culture, the mythology, the traditions of this land have no relevance at all, and we have to go on the basis of the United Nations Charter, or the UNCRC, which has not taken note of the peculiar requirements or the regional nature of the norms that are to be implemented, or the regional or socio-legal situations in the respective jurisdictions.
Indeed, Your Lordship. Your Lordship,
Counsel,
tradition is
you may
something.
please note you have 1 minute left.
Thank you.
I'm sorry, 5 minutes left.
Thank you.
Yes,
Your
madam. Go ahead.
Lordship, the council would like to contend that tradition is something which is very subjective and must not apply to criminal matters, Your Lordship, because I would like to point out that the traditional Eklavya story might be historically significant, but it no longer holds relevance in the modern day context, particularly
We are
when
on the
viewed.
Guru Shishya Parampara aspect. Leave alone the Eglavya story. We may admit that it is a mythological thing. But when it comes to Guru Shishya Parampara and the way in which the teacher student relationship has to be charted out, we have indeed our own ways of looking at it. So, why should that be given away with and substituted by this system, which is not at all local, or rather does not emanate from our own understandings of our social situations?
Indeed, Your Lordship, the Guru Sishya relationship is a relationship of mutual understanding and respect. However, Your Lordship, the Guru Shishya relationship in the present day concepts must not influence and encourage any kind of unquestioning obedience or sacrifices, Your Lordship. The concept of, in the modern day concept, education is centered around nurturing the rights and dignities of children. Your Lordship, subjecting any child to physical or mental trauma would violate these rights and would affect and obstruct with the natural development of a child, Your Lordship. Therefore, the Guru Shishya principle will apply in the present day concept as well, Your Lordship. However, this analogy has been made only to show that there is a bond of integrity and respect between both a teacher and a student. However, teacher is not given an absolute right over the child to inflict bodily harm, and that too without any reason, Your Lordship. The bodily harm and physical punishment
It is
can
part
affect
of
the.
our culture. It is very much part of our Indian culture that when a newborn child is there or a toddler is seen, you would go and pinch on its cheeks. It might suffer some pain. It is our custom, our practice.
Indeed, Your
We
Lordship.
may pinch on its cheeks. Can
Indeed, Your
that be
Lordship.
termed as an assault? Technically, it is an assault. A pain has been suffered. May it would fall within the all force of cruelty to the child, as laid down in section 75. So it can even be termed as an abuse if you look at it from that way. But we all know that this is something that we usually do in this part of, or in eastern parts of the globe. So the intent or the malice, as was laid down by the High Court of Kerala, insofar as that is totally absent, on the one hand, that is there. Secondly, the relationship between that individual and the child is that of a well-wisher, as pointed out by Justice Jayagumar. Then, coupled or reading together these two things, how can we criminalize, or how can we punish, or a penal penalty be imposed on a man to the extent of sending him to jail for 3 years, or with fine of rupees 1 lakh based on 75? So
Indeed, Your Lordship.
is it a mechanical application of the provisions of Section 75, or is law a purposive law is a purposive enterprise? There is a purpose. Shouldn't we look into the purpose of the law rather than applying it mechanically to every fact situation?
Indeed, Your Lordship. However, the Council would like to point to Article 14 of the
Counsel,
Constitution of
I'm
India.
very sorry, but you may please note that you have 1 minute remaining.
Thank you, Good Master. Your Lordship, the Council would like to point at Article 14, which prohibits arbitrary discrimination but allows reasonable classification. Your Lordship, the Council would like to contend that teachers and parents cannot be equated at a particular footing. Your Lordship, as you mentioned, the act of pinching on the cheek, Your Lordship, and the act of smacking and pinching in front of the entire classroom for any misconduct, Your Lordship, these acts cannot be equated. Moreover, Your Lordship, in the present scenario, the Guru Shishya analogy cannot
The
exist, as Your
intention.
Lordship.
Speaker,
Speaker,
What is the
you are
purpose of the act? Section 75. What is the purpose of the act? Whether it is to protect the child from the others or parents and teachers. What is the intention behind
Yes.
that act?
Yes.
Can
Your
it
Lordship,
curtail? Can it take away the rights of the parents and the teachers? When a child is doing a misconduct or miswrong, whether the parent or the teacher would keep mum. What is the purpose of the act? Whether it is to protect the child from the cruelty by some others or the parents and the teachers. In this context, parents and teachers to be considered together. So I will group them in one. That is parents and teachers on the one side and the cruelty from the other side. What is the main purpose of this act,
Yes.
according to you?
Your Lordship, the main purpose of Section 75 of Juvenile Justice Care and Protection Act is to prevent any unnecessary physical or mental suffering to the child caused by any act of assault, abandonment, or neglect from any other person. However, Your Lordship, the teachers cannot
So
be
the
excused.
parent and the teacher should keep mum. They should not guide them. You do this is right or this is wrong or this is the value you have to inculcate. They have to keep mum when the child he or she is doing some wrong. Then what will be the fate of the our nation? Then the child will grow as he so according to his own whims and fancies. Then what would be the fate of the society? What is the purpose of law? The welfare of the society, welfare of the people. Then how such a law can be, as it stands now, be good for the society? Public, whether it can say that Section 75 is doing public good. What is your opinion?
Indeed, Your Lordship, but the council is not contending that the teachers and
Council,
the
you may
parents.
please note your allotted time is over.
Your Lordship, the
let,
council
let,
just needs an
let her finish it. Let her finish.
Much
Yes.
obliged, Your Lordship. Your Lordship, it must be kept into mind, Your Lordship, that the teachers and the parents can use force, Your Lordship, as far as it's reasonable in accordance with the. Your Lordship, what the council is trying to contend is that the teacher could have used other methods. Your Lordship, the council is not trying to contend that the teacher should have kept mum when the student was doing any misconduct. However, the teacher should have used any alternative methods. Your Lordship's scolding could have been done, positive reinforcement could have been done,
If scolding is
reward.
done, that would be a mental abuse. That would
Uh,
amount to mental abuse.
No, Your Lordship, it is not necessarily reasonable to conclude or assume that a mere scolding can lead to a mental or psychological trauma. However, Your Lordship, teacher could have used, as has been mentioned in the Moot proposition itself, Your Lordship, various punishments have been there, are available, Your Lordship. There are verbal reprimands, there are proximity controls, taking away privileges like recesses to the students. Your Lordship, there are various methods that the teacher can take to administer discipline. However, Your Lordship, resorting to physical punishment is strictly against the constitutional fundamental rights guaranteed to the children under Article 21, as it violates the bodily integrity and autonomy of a particular child, Your Lordship.
Speaker, should we not differentiate the acts by well-wishers like parents and teachers and the acts by the strangers? One with love, care, and protection, and the other with malice. So when we understand the ingredients of the offense under Section 75, when it is done by parents or teachers, then we can we can apply the principle of mens rea and say that without any, it was without any intention, and it was without any deliberate intention and without any other malice that teacher or parents were doing a particular act. So should we not differentiate these two?
Your Lordship, the Council humbly seeks to defer as, Your Lordship, while some legal systems may favor parents within the limited discretion to use force, however, Your Lordship, teachers who function in an institution and legally regulated setting are explicitly prohibited from doing so. Your Lordship's parents are the natural guardians of this, of a particular child, and they are also exempted for using unreasonable, unnecessary extreme force on the children. However, your lordship, teachers can at no cost be accepted from the provisions or falling under the scope of section 75 of juvenile justice care, because your lordship, a reasonable classification has to be maintained here, and the teachers have to be held accountable for any kind of corporal punishment to prevent the normalization of corporal punishment in the present day scenario of the society, your lordship. Your Lordship, I just need 30 seconds to conclude my contentions. Much obliged. Your Lordship, in conclusion, the corporal punishment is an outdated and unconstitutional practice that infringes upon a child's fundamental rights under Article 29. 21. The High Court's decision to quash the proceedings failed to serve the ends of justice and overlooked the serious social implications and undermines the child's right to protection. The normalization of corporal punishment contradicts with the established legal principles, international obligations, and the progressive evolution of child rights. Therefore, the Honorable Court must allow the proceedings to continue and ensure accountability and reinforcement of a safe, dignified learning environment for the children. Your Lordship, if Your Lordships have no further questions, the Council seeks permission to proceed with the prayer.
Brother Shyam.
Yes, sir. Justice Jayagumar, sir. Any more questions? I guess you can proceed to conclude. Yes.
Much obliged. In the light of issues raised, authorities cited, and arguments advanced, it is most humbly submitted that the Honorable Supreme Court of India be pleased to declare that any act of corporal punishment is against the right to bodily integrity guaranteed under Article 21 of the Constitution of India, and the defense of using reasonable force or for the welfare of child cannot be allowed. Uphold the decision of Division Bench of the High Court of India convicting Shahudi under Section 75 of Juvenile Justice Care and Protection Act, issue an order or direction to the state of Dharmastan to ensure that all forms of corporal punishment are strictly prohibited in all educational institutions, and or issue any order, direction, or relief which the Honorable Court may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the respondents shall forever be duty bound. Much obliged. It was an honor to plead before this bench. Much obliged.
Now, the petitioner side may start their rebuttals.
Council seeks permission to continue with the rebuttals.
Yes.
Your Lordship, Council would like to firstly start with the issues that has not been dealt by the co-council, dealt by the council for the respondent. As in the present case, they have not argued upon the maintainability of the present case, and they have not even argued upon the media guidelines that are being prayed by the appellant in the present scenario, which can be concluded that they do not have any further issues regarding issuing of guidelines and maintainability of the petition in the present case. Secondly, in the current matter in front of the court is in relation to quashing of the proceedings and not on corporal punishment being not defined, as the prima facie no malice from the teacher has been established and the act done has not caused any unnecessary or physical mental suffering. Therefore, there is no prima facie offense has been established, and hence it has been stated in the case of State of Haryana versus Bhajanlal that the power given to High Court to quash the proceedings when the prima facie offense being established as by the accused. When the prima facie offense has not been established, court has the power to quash the proceeding. So, as rightly pointed out by the honorable bench, that why the teacher in the present scenario has to go through the rigorous process of the trial when no prima facie offense or offense under 118 and 75 of the JJ exist for him.
Also, as the bench mentioned the case of Sindhu Shivdas, it is applicable in the present case as it shows that the good faith can be a reasonable measure as it exists in the case of Sahudeo and the precedent that has been taken from the case of Sindhu Shivdas also. As the as the counsel for the respondent has also stated that there has agreed that there is no abuse in the reason there exists no abuse from the side of the teacher. That's the reason the rights of the teacher are needed to be protected in the present case, and he should be refrained from going to a trial process that will violate his dignity in front of a society that is needed to be respected in a profession like the teaching one, which the accused have in the present case. As Furthermore, moving to the other rebuttals, as the sociological school of jurisprudence says that it is the society that shapes the law and not the law that shapes the society. Even the honorable bench agreed upon that issue these are the customs and the backbone of the Indian Union, that it has respected the authority of the teacher from the decades and the centuries, as it cannot be violated in the present case too. Continuing with my further rebuttals.
Where from would the sociological jurisprudence emanate? Does the sociological jurisprudence have any relevance when it comes to interpretation of criminal legal statutes?
Your lordship, it basically it
Who
says
is the father of sociological jurisprudence, generally speaking?
Roscoe Pound, your lordship.
Yes.
So it starts with the saying that laws do not exist in a vacuum. They are to be considered as they are to be considered with the societal norm that exists, as the societal norm being present case that the corporal punishment has been a measure that is to be dealt to prevent the child from doing any indisciplinary actions in the classes, your lordship. As the contentions mentioned that the obligation of the Indian Union towards the binding obligation of UNCRC, as it has been already pointed out by my co-counsel during the submissions, that UNCRC do not hold any binding value on Indian Union. It is the domestic laws that hold the binding value, and being submitted that JJ Act.
What is the procedure for implementing a international convention through Indian courts?
Your Lordship, Article 253 of the Indian Union Constitution state that legislature may take in the shadow of the international obligations can frame the laws which do not have any contravention with the existing rights of the people in the country.
Would being a part of an international convention make those dictums or make those legal norms part of Indian national law?
Your Lordship, until and unless there exists no domestic laws in furtherance to the commitment that are in any international convention, they do not create any binding effect on the courts or the Indian Union.
So if there are no local norms, the international convention would have a binding effect.
Can you repeat the question, Your Lordship?
So if there is no local norm that would conflict with the international norm, the international convention would have an effect in Indian could be implemented through Indian courts. Is that what your contention is?
No, Your Lordship, as the Indian Union follows a
Counsel, your allotted time for the rebuttal is over.
Council seeks extension of 1 minute to as Indian Union follows a dualist approach which is needed to be interpreted, the domestic legislations are kept in the hierarchy, are kept above considering the societal norms of the societal norms in the present scenario. And for continuing with my last rebuttal, it said as it has been pointed out by the counsel for the respondent that section 17 clause 1 of the RT Act stands to be violated in the present case. Your Lordship, it is being humbly submitted that RT Act is not a penal provision. It is a provision that is stated for the welfare of the children and to maintain a decorum in a classroom, which is needed for the educational learning environment in the present scenario and in the working of educational institutions, Your Lordship. Council is completed with the rebuttals. Thank you, Your Lordship.
The respondent side may start their rebuttal.
Council seeks permission from Your Lordship to start with the rebuttals. Your Lordship, with respect to Section 17(1), the councils have submitted in the Act that India has prohibited the form of corporal punishment, any form of corporal punishment. So it has been used by the council in respect of that. Your Lordship, secondly, the case of Sindhu Shribdas cannot be relied upon because the factual matters of that case said that the teacher has merely scolded the child. Therefore, it cannot be included in the ambit of Section 75. Whereas in the present case, there has been a use of physical force. Therefore, therefore the use of force can come under the ambit of Section 75, Your Lordship. Your Lordship, with regard to international conventions, Your Lordship, as the councils have pointed out that Article 51, Clause C of the Indian Constitution, it is obligatory on the India that state shall endeavor to foster respect for the international treaties and international laws and treaties, Your Lordship. Your Lordship, with respect to banning of corporal punishment, the council would like to state the case of Parents Forum for Meaningful Education versus Union of India, Your Lordship.
Another international treaty to which India is a signatory, UNHCRC, it prohibits employment of children. India has not chosen to implement it. In Shivagashi and in the hotels across the country, we find children being employed. So that is not being strictly implemented. Can we implement some part of the provisions of the UNCRC and ignore the other part? Is that the way in which an international convention is to be brought into the Indian legal system?
Your Lordship, there is a ban on employing children below the age of 14 years in any employment, Your Lordship. There is a ban. The children cannot be
Question
employed.
is whether it is being implemented in the same fervor with which it is being implemented against the teachers.
Your Lordship, can you please rephrase?
Whether the prohibition against child employment is being implemented in the same fervor and in the same interest and the same enthusiasm as we see in the case of implementation of these rights vis-a-vis the child and the teacher.
Your Lordship, prohibition of children from prohibition of employing children under the age of 14 years is also to encourage the child rights, Your Lordship, that childs cannot be exploited. The tender age of the child cannot be exploited.
We don't see it being practically implemented.
Your Lordship, but India is taking all the measures it can to make sure that no child of the tender age is employed in.
As Justice Jayagumar was pointing out, that is a classic instance where those who are not interested in the child are exploiting the child, and they go scot-free. On the other hand, well-wishers of the child, when they do something so as to discipline the child, now they are visited with criminal proceedings. We cannot let this dichotomy to continue.
Your Lordship, the council here is contending that the child's rights cannot be subjected, Your Lordship, because, Your Lordship, in this evolving era where the child rights have evolved to recognize the dignity of the child, Your Lordship, we cannot go back to the age-old concept where there existed no rights, Your Lordship.
Yes.
Your Lordship, I would like to also state the case of Parents Forum for Meaningful Education versus Union of India. Your Lordship, the High Court of Delhi has observed that in today's era, it cannot be said that parent and quasi-parental authority have the power to use reasonable force to correct the child. And therefore, the court struck down the Delhi School Education Rule 1973 that allowed the use of corporal punishments, Your Lordship. Your Lordship, also, in today's context of evolving child rights, the story of Ekalavya cannot be relied as because the teacher asked for the thumb of the student. Your Lordship, in today's era, it cannot be considered as a reasonable and it violates the child right. Therefore, one cannot rely.
That was not intended literally. It was just pointed out as a part of our mythology. That is all. Because it was not
only
as if that they
casual reference.
Casual reference, very true. Very
Your Lordship, indeed, Your Lordship. And Your Lordship, there exist other corrective measures which the teacher could have used, like scolding, informing about parents, and counseling, Your Lordships.
Yes.
Your Lordship, now I would like to submit my sub-rebuttals here.
Counsel, your allotted time is over.
Has he finished? He finished your.
Your Lordship, the council would like to raise their submissions on the sir rebuttals here.
You have completed. Yes.
It was an honor arguing before this honorable bench, Your Lordships.
Yes. So, court officers, that is the end of it, isn't it? So, we are.
With the judge's kind permission, shall we conclude the session?
Yes, subject to. Yes, yes.
With that,
Yes.
the final session of the 34th National Moot Court Competition 2025 has come to an end. Thank you, participants. You may please leave the session. Thank you, judges.